वेलकम एंड गुड मॉर्निंग फ्रेंड। आज सुबह सुबह संडे को इतनी भीड़ देख करके काफी अच्छा लग रहा है। और आई थिंक आज के जो स्पीकर भी हैं वो तीनों स्पीकर ऐसे हैं कि लास्ट तक आपको उठना नहीं है। वी स्टार्ट आवर सेशन विथ आवर आईसीआई मोटो, प्लीज स्टैंड अप। जय हे भारत भाग्य विधाता, पंजाब सिंध गुजरात मराठा द्राविड़ गंगा, विंध्य हिमाचल यमुना उच्चल जलधि तरंगा। जब शुभ जागे तब शुभ आशीष मांगे, गावे तब जय गाथा। जन गण मन नायक जय भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे। भारत माता की। फ्रेंड, आज के हमारे फर्स्ट स्पीकर CS राज कपाड़िया जी, जो हमें रिसेंट अमेंडमेंट इन कंपनी लॉ स्पेशली फॉर प्राइवेट कंपनीज उसके ऊपर डिस्कस करेंगे। आई रिक्वेस्ट CA पूर्वी फगेरिया एंड CA सीमा मेहता जी टू इंट्रोड्यूस हिम। अदरवाइज उनको अपने यहाँ इंट्रोडक्शन की जरूरत नहीं है। ही इज वेल नोन मेंबर। प्लीज।
Hello, good morning. Today, our speaker CS Raj Kapadia. The topic for the today's session is Amendments in Companies Act applicable for private limited companies. Mr. Raj Kapadia is a fellow company secretary and law graduate. He is founder of RK Kapadia and Associates, a peer review firm providing full range services to the global clients in setting up of businesses in India and handhold them under applicable compliance, statutory regulatory representation and intellectual property rights aspects. He is registered as trademark professional under the Trademark Rules 2017. He is a program graduate from IIM Ahmedabad. He has completed postgraduate diploma in digital business jointly from Columbia University and MIT Sloan. He has been co-opted as member of Professional Development Committee of WRC of ICSI. He has been elected as convener in the Commercial and Allied Laws Committee of Chamber of Tax Consultants and also active member of Research and Publication Committee of Chamber of Tax Consultants. He has addressed professional bodies including the ICI and study circles of WRC, ICI and Chamber of Tax Consultants. He has been a faculty before various forums, including the IIT Indore. He has also contributed articles for professional bodies, including CCGRT and of ICSI and Chamber of Tax Consultants. With this brief introduction, I invite CA Anil Sharma, past convener, JB Nagar Study Circle, and Jayesh Bhai Thakkar, past convener, JB Nagar Study Circle, to present small moment.
I also request CA Dani Khanjalwal to come, please.
हेलो, राज कपाड़िया का कल बर्थडे था, तो हम लोग उनको बिलेटेड विनी हैप्पी रिटर्न्स ऑफ द डे विश कर रहे हैं। थैंक यू। विश यू विनी हैप्पी रिटर्न्स। थैंक यू।
Good morning, and I thank CS Seema ji for the wonderful introduction, and thank you very much for the birthday wishes. It also happens to be a PCS day yesterday, so it's a mark of destiny that the birthday and PCS day are on the same date. I thank the coordinators at the prestigious JV Nagar Study Circle for inviting me to address on the topic of the recent amendments under the Companies Act. And welcome to all the participants on the Sunday morning for the same. It's always a very special session. This session is even more special to me because my trainer, Dani sir from Dani Costing, is here as a participant. So, so regarding the amendments, so recently, the erstwhile Finance Minister, Madam Nirmala Sitharaman ji, who has been re-elected for another term in the current government as well, she had an address with the professionals, the chartered accountants, the cost accountants, and she stressed the need in that the theme of the session was a role of professionals in Viksit Bharat, the Amrit Kal, which is currently there. So, in that, she stressed the need for that the professionals have need to create awareness for ensuring compliance for a better governance. So, the focus of the government was to create a good governance culture, and she also stress that every small, medium, and also large companies benefit for itself, not just for itself, for its shareholders, for its stakeholders, and for the country as at large through a good governance. So the stress was on governance, and we will see through the amendments as well how good governance culture is being promoted very recently. Like for example, we will see that quite a few approval related services of the ministry have been centralized. There is a central processing center which have opened for quite a few approval related services. There are quite a few forms which are stayed through. So those and other adjudication related matters are now with the jurisdictional registrar of companies as well as the regional directors, the RDs. So this is how. So now focus is on good governance, on compliance, on correct disclosures. We will the flow briefly will be that we will be discussing the amendments. Then we will be covering the brief of the DMAT provisions which have been introduced and which are to be complied with, the beneficial ownership and the related provisions. So there are some amendment in beneficial ownership as well. Of course, these provisions have been in effect, but there are some recent amendments as well which we will be covering. We will be also, as we discussed, the RD and ROC are now focusing on good governance, on correct disclosures. So those adjudication orders recently. So we will be covering what all are the aspects as per those orders which are to be taken care of, and what exactly are the orders we will briefly discuss. And time permitting, we will have time for question and answers as well. So starting with the first amendment which has been introduced recently, which is in on 19th of February 2024. I hope this is visible at the back. So this was like one of the technical difficulties wherein you required a master data collection, and for that you had to raise complaints or follow up with the help desk and other things. So to address this, basically a change request form has been introduced in the new V3 portal. So this is for some minor errors which would have taken place, whether it is errors pertaining to some typographical error, some transposition, and those things. So for that, there is a special this change request form which can be done. It's a web form on the V3 portal. It can be filed and the change can be initiated. Of course, it is not to be used for any aspect for which there is a specific process which is there. For example, change in share capital, there is a process. Change in registered office, there is a process. So for those, this form is not to be used. That is to be taken care of. So it is not as a substitute for any existing process. For existing reporting requirement, any approval related service. So for those service, this form is not to be used. Otherwise, this can be made use of. Next is, as we discussed at the start, this centralized processing center. So with effect from February of 2024, again, this notification has come wherein quite a few forms, basically which are approval related forms, they have been centralized. So that jurisdiction has now moved from the local the jurisdictional registrars to the centralized center. It has been opened at the office of Indian Institute of Corporate Affairs at Gurgaon, Haryana. This the registrar of CPC will now process the forms and dispose those e-forms along with fees. And jurisdictional ROC and the RD will have jurisdiction in respect of all other provisions. So we will have a look at what forms have been centralized. So these forms largely pertain to, of course, the incorporation of service, which is with the centralized registration center. There is a strike off related also, which we will cover, which is also being centralized now. Instead of local registrar, the strike off related, the closure of company related also have been centralized. The forms relating to share capital, whether it is the increase in authorized capital, whether it is buyback related. So those changes in share capital also have now been given to the centralized this processing. So these are basically the approval related forms. There are some other forms which are straight through, like you upload and it will be registered, whether it is the pass through, which is allotment of shares, whether it is the changes in directors, all these are straight through forms. So those have not been touched. Those are in any case, they are like you file and they will be taken on record. And if there is any
My
further
network
queries,
का
will be separately issued a show cause notice with respect to those forms. So, like which forms are there? One is the resolutions under section 117 of the Companies Act. So, what is that section? There are some resolutions. So, earlier in 56 Act, private companies were exempt from filing all the resolutions, but in this Act, there are a few resolutions which are to be filed with Form MGT 14. So, those will be processed by the centralized processing center. So what is the first is the special resolution. So whether in any general meeting, any special resolutions, every special resolution has to be filed with MGT 14 now. So those are there. Second is a special majority.
PDF दिया आपने
PDF वाला कर दीजिए ना, PDF में दिया था। दो
इसको पूरा मिनिमाइज करो, स्टॉप शेयर करो। Sorry, just technical glitches. I just cleared it. ये वाला कर देती हूँ, अब इसको शेयर कर देती हूँ। इसको देखिए।
Is it visible?
Please put your phones on silent.
Hello. Is it visible?
Which are all the forms in both from all over the states.
Yes.
Wherever the companies are.
Yes, yes.
Not only for.
It will be centralized. Yes. So that is basically the main amendment.
So all these will be handled by CPC.
Centralized.
Like income tax. And others, we go to local.
Local, so whichever are not covered, or there are other straight through as well. So even those can be then scrutinized, and if there is any discrepancy, they can issue a separate this notice for that. So now that governance now will take more focus, it seems. That is what. Yeah. So one is the special resolutions and second is special majority. So if there is any resolution wherein a special majority is required, this is majorly found as a special provision in the articles of association, or if there is any shareholders agreement or such agreements wherein a special majority is required in that, not the special resolution, but the majority, say 2/3 majority or that, like that type of this situation. So those resolutions are to be filed. This is applicable to all the companies. Terms relating to MD, whether it is appointment, like change in any change in the agreement or any change in the terms relating to the private companies, you are not required to comply, like those provisions of remuneration and percentage of profits and all, section 197, 198 is not applicable to private companies, but the resolutions which are there, which deal with those aspects, also are to be filed. Winding up related resolutions, if any, whether so those are to be filed. And next is 179 subsection 3 of the Companies Act, which is exempt for private companies, but for other than this public, listed, unlisted, they have to file this. So for private companies, so those include calls on shares, this buyback related resolutions, which for private companies is not required to be filed in MGT 14. Borrowing related investments, guarantees, resolutions, financial statements as well. For private companies, it's not applicable, but for other companies, even for approval of financial statements, these resolutions are to be filed. Amalgamation, mergers, reconstructions, giving of political contributions, appointment or removal of KMP. So only MD is there for private, but for other than that, any KMP, the key manager person, is to be filed, and internal or secretarial auditors appointment or such resolutions are to be filed. So this is about MGT 14, largely MGT 14 form. Next, what other forms are there? One, yes. Not applicable. So not applicable for KMP. Suo motu, wherever not applicable KMP, even then voluntarily company has. Of course. Yeah. So the CEO and those CFO not required to be filed because the act has specifically exempted. So.
Right. Question answer from community.
Sure. Next is the this relating to share capital, as I told at the start, that share capital related, whether it is increase in authorized capital, any division or like a split. So that is in SS7. Then there is a change of name form, which is also they like centralized now. INC 24, which is a change of name you have to file. This INC 6 is conversion of OPC into other than OPC, whether it is a private company. So that is in INC 6 is to be. OPC is one person company. INC 27 is private to public company, public to private company. This INC 20 is a Section 8 company if it wishes to surrender the license, the not-for-profit companies. DPT 3 is here, it is return of deposit, but then particulars of return other than deposits, which is an annual requirement, which is due by 30th of June. That also will become now centralized. This approval is centralized. For this person, it is a state through. For particulars which are not considered as deposit, which is an annual requirement, it is a state through form, but then the jurisdiction will go to the centralized processing center. Then if we have to update any status of dormant company, or you have to like convert a dormant to active company, those forms also are centralized. Buyback offer, like we told about share capital again. So buyback related forms are there. SH8, SH9 is declaration of solvency at the time of buyback itself. 11 is the return of buyback. So all these forms are now centralized, subject to centralized processing center, not the jurisdictional ROC. So next amendment relates to again very important. This is about direct listing of the companies in foreign jurisdictions. So where it is, this was introduced for the first time in Companies Amendment Act in 2020. It was made applicable with effect from 30th of October 2023. It was made applicable. It was introduced in the Amendment Act 2020, which enabled the Indian companies for a direct listing in foreign jurisdiction. So permissible, it was permissible, but in only in permitted foreign jurisdiction. It was like they have clearly specified in the rules. We will discuss which jurisdiction and which stock exchanges are permissible. The rules which are listing in permissible jurisdiction, they have been notified in January 2024. Under these rules, the unlisted public companies and also listed companies with conditions as per SEBI. So SEBI, these regulations are to be complied with. Also subject to the compliance with Indian accounting standards, which have been notified. Also subject to those compliance, the prospectus, once it is filed with the SEBI and the exchanges and it is approved. So within 7 days of that approval of the prospectus, we have to file the prospectus in form LEAP 1 within 7 days of finalizing and filing with the stock exchanges. So this new form which LEAP 1 is introduced here, wherein the prospectus for direct listing in foreign jurisdictions. So which are this as per the LEAP this rules, the permitted stock exchanges are International Financial Services Center in India, which is in the GIFT City. So this IFSC, and the permitted stock exchanges are Indian International Exchange and NSE International Exchange. So only in these for enabling these listing, these rules have been notified, and companies which are not eligible to be listed is of course a Section 8 company, Nidhi company, guarantee company, which is also having share capital, but it is a guarantee company, so not this. There is any outstanding public deposit under chapter 5. So this, if there is any such outstanding deposit, there is a negative net worth, then it is ineligible. There is a default in payment dues to bank, public finance institution, or debentures or secured creditors. Any default is there, not permitted to be listed in these stock exchanges. But if 2 years have lapsed, 2 years have lapsed, and this default is made good, and 2 years have lapsed, so then this default then it is good, and you can list. So 2 years have this gap has to be followed. If any, of course, winding up this is already in process or it is initiated, then it is ineligible. And default in filing of financial statements, annual returns, then it is not permissible. Then it is another important amendment which was introduced. Excuse me. So here the companies, basically it was enabled to shift registered office. It was specifically introduced in October 2023 for companies wherein the restructuring was allowed. So it was already restructuring was done. The new management had taken over after the IBC process. Restructuring, new management, the resolution plan was already approved. In that case, it was allowed to shift the registered office outside the jurisdiction of the state or the local registrar of companies. So this was the amendment which was there. There is no inspection investigation pending against that company, only that condition was there. But to enable smoother functioning, this shifting of registered office was allowed, and this was excluded, which is may include order as to cost. So such order for shifting was allowed, but that payment of cost and all those things were excluded. So without any such cost also, the order could be now issued for shifting of registered office. So it was as a convenience this. Next is the as we so this is about the we'll do the second this. So there was first an amendment and there was a second amendment for removal of names. So first we will do the first one, wherein as we discussed about the centralized processing center for incorporation and other related. This was for strike off, which was introduced in May of 2023. CPACE, which is the Register for Center for Processing Accelerated Corporate Exit. In this, there was this STK2 form which is to be done with a filing fee of 10,000 this rupees, and you have to file, and this the strike off related will be now processed by CPACE, which is the this center for this accelerated corporate exit. Then there was a second amendment as well, which is introduced, wherein for such a removal for strike off, before initiating such a strike off, all the annual returns and this financial statements have to be filed up to the end of the financial year in which the operations business have stopped. So not till the time of filing. Wherever you mention that yes, we have stopped our activities, but care also has to be taken that under Companies Act you are saying that you have stopped, but is the bank account active? So bank account closure is done. GST number. So like GST number is active, but you are saying that the activity has stopped. So all those discrepancies also may come up, that why this is, then we have to explain. So that care has to be taken, that stop the activity, that means that bank accounts also are like closed, the GST number is also not active, so no other process, simply the company is ready to be struck off. So then till that time the annual returns financials have to be filed up to the end of financial year in which it is ceased to carry operation. And this if it is any this if any notice is sent by the registrar to the company for striking off under section 248, if registrar has initiated such a notice that you like for whatever reasons, say for example non-filing of annual returns or financial statements, if registrar has initiated such a notice, and in response if the company is filing the application that okay, we are only suo motu doing the strike off, even in that case all the overdue financial statements first and annual returns first you file those, and then the this application for strike off is to be processed. Then this if this 248.5 is when the registrar has issued already a notice for that the company will be struck off due to XYZ reason, and the registrar has ultimately went on to strike off the company under section 248.5, the registrar has issued the notice that the company is struck off. After that the company cannot voluntarily allowed to file application, because the action is taken by the registrar itself. Company cannot go suo motu. So as a consequence of registrar's action, the other things also may follow. For example, the disqualification of directors because of non-filing of this financial statement. So those consequences also may follow. So that's why once that action is initiated, companies cannot go and suo motu file a strike off application. That is also one of the amendments. So next, after that, we come to this multiple logins on the portal. So here also we had a clarification issued by the ministry as well, owing to the like shift in from V2 portal to the V3 portal. There were many teething troubles. There were like still, I mean, they are ongoing, and we are still in the process of like fine tuning the portal. But this specifically was issued, the clarification which was issued, that like in the migration process multiple logins were created, whether on the same email ID, same using the same phone number, using the same particulars of as a professional, as a membership number also. Multiple logins on V2 as well as V3 were created, which was giving issues while creating the login on V3 portal from the old V2 portal. So in that case, multiple IDs were created, the V3 logins were unable to process. So the what can be done is that request for merging or deactivation of the duplicate IDs. So for that, earlier we had to get in touch with the help desk or like raise a complaint for such multiple IDs, and then that used to be processed. So now the clarification which was issued is that in such case where professionals have a duplicate IDs, so the respective this professional institutes, ICI, ICMA, ICSI can be approached, the mail can be sent, and then from the institute's end, all the consolidated such requests can be consolidated and forwarded to the ministry so that they can take the appropriate action. That is what clarification now, that is also a process. But nevertheless, like once registered on the V3, so now that V3 portal is active, the new registration on V2 is not happening separately. We have to register as professionals on the V3 portal. We have to enter all the details, like enter the OTPs which we would be receiving, and the V3 ID, the V3 new portal would be created, and the particulars of V2 ID would be sent to mail within few hours of creation of V3. So now that is so directly now on the V3 portal, the new registrations would be happening. Next is the clarification with respect to conduct of the general meetings for all the companies. Under the COVID restrictions, we had this circular on 8th of April 2020 for conduct of general meetings through audio-visual means or through virtual means. Now, the circulars, like multiple circulars were issued. This one was for this one was for the 14th of 2020 was for general meetings. Likewise, we also had for board meetings. But surprisingly, we have not yet had any amendment in the Companies Act or the rules. So for the board meetings, what happened was that the rule 4 of companies meeting of board and powers rules were amended. So earlier what used to happen was that certain aspects were to be dealt with in a physical board meeting. Virtual, those items were not allowed to be held in virtual meetings. Physically, board had to be present. But due to the COVID, these difficulties, the temporary circulars were issued, and thereafter those rules were removed. So now for board meetings, this approval of financial statements virtually also is possible because those rules have been removed. But similar amendment yet for general meetings have not been issued. So we are having circulars every year wherein the timeline is getting extended. So again, this circular is there. So wherever general meetings are due in 2023 and 24, till the 30th of September 2024, all such general meetings are allowed to be conducted virtually through other audiovisual means or through the video conferencing. Of course, those the original circulars and thereafter whichever are issued, those guidelines will continue to be applicable along with the secretarial standards also will have to be followed. But this is the status currently. We have not had such amendment, the corresponding amendment for general meeting. We may have, we may not have. That is the question to be seen eventually. But currently till 30th of September 2024, this relaxation has been done. We may have such a this similar amendment in the rules eventually. So now we come to an important aspect, which is a significant beneficial ownership. So of course there has been some amendment here, but I thought that it is a critical this important aspect under the Companies Act. So we will discuss briefly the provisions as well, and also the amendments under the significant beneficial ownership these rules. So these are like there are two portions in the SBO rules. One is section 89 and one is section 90. So for both under the Companies Act along with rules. So we will discuss briefly both the provisions rules, procedures, forms under section 89 and also under section 90 of the significant beneficial ownership. We will discuss the categories of members which are there under the rules which can be considered as SBO. The rules we will discuss briefly, the procedures we will discuss briefly. First is the beneficial ownership under section 89. Both are different. We will try to understand what is the main difference between 89 and 90. One is the beneficial ownership. So normally, so here in section 89, there are two types. One is the registered owner and one is the beneficial owner. Registered owner means the shareholder whose name is registered under the Companies Act records, under whether it is the register of members or whether the name under which the certificate also is issued. That is the registered owner, which is on records. Beneficial owner is a natural person. Natural person is important. Natural person or persons, so jointly as well, who ultimately owns or controls interest in a legal entity arrangement such as a company, trust, or foundation. So registered owner is on the record, but beneficial owner is the natural person who is ultimately has interest in that securities. So interest not just under shareholding, it is mentioned in control, which also we will discuss. Controls is a very wide and critical term here. We will discuss in due course. So registered owner, but not holding a beneficial interest in those. Registered owner not holding a beneficial interest has to file declaration to the company in MGT4 within 30 days from the event. So whether he or she has acquired any such in this interest, or there has been a transfer, or whether, like, typically it is not given this example, but we can take example of a wholly owned subsidiary. But just for a case of private company, minimum 2 shareholders, we have a registered owner, but then beneficial interest is in a single entity. So in such a scenario, within 30 days of such an interest being created, this MGT4 is to be filed with the company. So this is to be lodged with the company, informing that yes, I have beneficial interest with respect to so and so share. The names and other particulars have to be given. The particulars of beneficial ownership we will discuss in controls. When we discuss control, what type of the ownership can be there in the beneficial ownership. So for a beneficial owner, holding or acquiring beneficial interest. So this first is a registered owner. Second is, for a beneficial owner also, you need to give a declaration in the company that I am holding this beneficial interest, or I have acquired this beneficial interest. The declaration is in MGT5. So MGT4 is for registered owner giving this declaration. MGT5 is for a beneficial owner giving the declaration in the company within 1 month of any event. So what are the particulars briefly in MGT4 or MGT5? It is not an e-form. It is to be like submitted in the company. So the details, the basic KYC details of the registered owner, beneficial owner, the particulars of shares, what is the type of ownership which is there, declaration of beneficial ownership being this beneficial interest being obtained, detail of interest and reason for not registering the shares in the name of beneficial owner. So why beneficial ownership is there and why not a registered owner? Why beneficial owner is not a registered owner? That details also have to be mentioned. And if there is any change also, we need to do that. So like any event, 30 days within the event, we need to comply. The penalty also for non-compliance is prescribed, which is 50,000 rupees, and for like 200 per day for like each day wherein this is a continuing default, and maximum prescribed is up to rupees 5 lakhs. Thereafter, like once company has received these details from the registered owner and beneficial owner, the company has to make the e-filing. So this e-filing is MGT6, which is the company has to inform to the registrar the particulars of the shares which are subject to. So what are the this included in MGT6 is the particulars of shares which are subject to beneficial ownership, the particulars of the registered owner, the beneficial owner. For failure, if MGT6 is not filed by the company, then the company plus officer in default, there are the penalty prescribed 1,000 rupees per day up to 5 lakh rupees for a company and 2 lakh rupees maximum for the every officer in default. It is rights against those shares are not enforceable by the beneficial owner by the company as well if declaration is not made. If declaration is not made, no right is enforceable, and there is also no prejudice on company's obligation to pay dividend in respect of those shares if this has not been complied with. Beneficial interest. So what is included in a beneficial interest? It includes whether directly or indirectly via as well. So indirectly also has to be seen, not just the direct ownership through any contract, arrangement, or otherwise. A right or an entitlement. Person alone or together. We will discuss this as well. So together as well, acting together with another also would generate a beneficial interest. Exercise or cause to be exercised, any or all the rights attached. So many important things through any this arrangement, agreement, any such thing, any right or entitlement, person alone or together, who to exercise or cause to be exercised any right or rights attached and to participate or receive dividend, that is also included. So this all is included in a beneficial interest. This has to be seen by all the companies. And these rules, so these we are the here we these rules, the beneficial ownership rules will not apply in case of a trust, which is like for mutual fund or venture capital fund or such funds, which is like approved by the SEBI. So for these cases, the beneficial, these rules will not apply. Also on the government companies, these rules will not apply. And only for a IFSC company, so whether public or private, which is in IFSC, so for these companies, instead of 30 days, the 60 days time limit has been given for MGT6. Otherwise, it is 30 days. So this was one of the amendment in this case, that person to be designated. So here also, like we said, the person has to be like responsible as an officer in default as well for the like in penalty also we saw that the penalty was on the company as well as the officer in default. So person has to be clearly designated and responsible for making the disclosure under beneficial ownership. So who is the person to be designated? One is the company secretary wherever applicable, or also voluntarily as well if there is a company secretary which is appointed in a whole time in the company, then also the CS would be there, or any KMP other than the company secretary which is there. Or if the KMP is also not there, then every director if there is no CS or a KMP. So such a person is to be designated in this order, and until that time, until the person is not designated, the company secretary is by default applicable if and where the CS is appointed. If not appointed, then every managing director or manager in case a CS is not appointed, and if MD or this is also not appointed, then every director is responsible till the time a person is or officer is designated by the company. And wherever such a person is designated, now this will form a part of annual return, the NGT7, when it is filed for all the companies. The details of that person have to be a part of this annual return. And also, if there is any change in that designated person, then it has to be like informed to the registrar in GNL2. So this is the amendment which was there, that any change has to be intimated and the details of the person who is responsible has to be in the annual return. So this was about section 89, which, like, briefly we discussed that it is a beneficial interest basically, and mostly it will be either by form of any agreement or in the form of a wholly owned subsidiary. Mostly in such a cases we will get a instance of a beneficial interest. Next is section 90, which is also very critical, which is a register of significant beneficial ownership, which is SBO. We'll call it as SBO under section 90. So we will discuss briefly the same. So again here, individual, whether acting alone or together. So individual, the owner is always a natural person, as we discussed in 89 as well. Here also it is an individual. So ultimate individual who is the beneficial owner, that has to be seen. And we also had, like, many companies received such a mails from the ministry directly. It was an informative mail that this section 90 in so and so cases have to be followed. If not, then if it is not done, then please comply. So it was an advisory come informative mailer which was received. For many companies received it around September, October of the previous year, and the same had to be complied with. Ultimately, it is to be seen that wherever if we have a layers of companies, then the ultimate, if there is any such individual, whether alone or together, directly or indirectly, holding that interest. We will discuss more in these rules. Acting alone, the individual acting alone or together through one or more person, through a trust or a person resident outside India. Beneficial interest of not excuse me. Beneficial interest of not less than 25% or such other percentage as prescribed, like not less than 25% or such other percentage as prescribed in shares, or a right to exercise or is exercising control. In such a case, that individual has to file a declaration with the company, not a e-form, but this is with the company in form Ben 1. And the company, if the company has received such a declaration in Ben 1, then the company has to update the register in Ben 3. Company has to maintain a register of such an interest declared and changes, including the particulars of in form Ben 3. We will discuss what has to be there, whether it is a name, the DOB, the basically KYC details of the beneficial ownership and the detail of ownership. We will discuss the ownership as well. And register is to be open to inspection by any member during business hours for not less than 2 hours on every working day as may be prescribed, and payment of fee not more than 50 rupees per inspection. So Ben 1 is to be filed by the owner, the beneficial who has beneficial ownership. Company has to maintain, based on Ben 1, company has to maintain the register in Ben 3, and that register is to be open for inspection by any member during business hours. At least 2 hours on every working day. The company can make such a like suitable resolution for the hours wherein it is to be kept open for inspection, and the fees for it not more than 50 rupees per inspection. So what are the part of this? What are the contents of Ben 1 and Ben 3? On the left is the register, which is to be this Ben 3 with the company maintenance, and on the right side is Ben 1 details which are to be there. So for Ben 1, for the purpose of Ben 1, whether it is a beneficial ownership or whether there is any change in that ownership. In that case, the Ben 1, the beneficial owner like gives in the company, stating the particulars of beneficial ownership, And nature of indirect holding, if there is directly or indirectly, if there is a beneficial interest, then also the Ben 1 is to be seen, not just the direct holding, indirect as well. So nature of indirect holding through any member. So what can be there, we'll discuss that, how indirect holding also needs to be seen. The status of SBO in member, whether the beneficial ownership indirectly also holds some securities, and also directly if that member is a registered holder, even in that case the that has to be disclosed in this Ben 1. And whether any direct holding, as we saw, the direct holding of SBO also has to be disclosed, and based on that the register of beneficial ownership which company has to maintain, the of course the details of the company, the KYC details of the beneficial owner, the date where the declaration was received in the company, cessation as well. So when the that person ceased, that individual ceased to become the beneficial owner also is to be mentioned. The date when it was entered in the register, date of filing the Ben 2, which is based on the declaration received in the company has to make the filing before the ROC. So that date when this was filed in Ben 2 along with the SRN number, and any instructions, specific instructions, whether with respect to interest in that beneficial ownership, whether it is any dividend, any such specific instruction as well uh, has to be it will be a part of this register. Next is the as we discussed about Ben 2. So once the company receives such a declaration, the return of beneficial ownership and including any changes is to be filed by the company with the registrar within 30 days of receipt, along with the fees as applicable. Ben 2 is the form. And also not just the this receipt of declaration, but the company as well shall take necessary steps to identify. So company has any grounds to believe that there is a situation of beneficial interest, then company also will have to take necessary steps to identify such a interest. And also and if like steps to identify individual who is a SBO in relation to the company, and require him, call for the information and require him to make the declaration in Ben 1. So company also obligation has been given based on financial statements, or based on any details which are there, based on probably any director. For example, every director is to give a disclosure of interest every year before the first board meeting. There is a form MBP1 which the director has to file with the company. If through that form company is aware that okay, this person might end up becoming a beneficial ownership, because there the director's shareholding is to be mentioned in other companies. So all that too is to be correlated, and the responsibility is that is placed on the company as well. If company is aware of such a situation, then company has to take the steps and call upon the individual to either comply or clarify that okay, I am not holding SBO, then I don't need to clarify to file. Briefly, what are the details in Ben 2? First is the purpose of filing, whether it is the declaration this of a holding company as well, or a beneficial ownership, or if there is any change in the beneficial ownership, then that has to be filed. The manner of beneficial ownership, whether it is through shareholding, voting rights, not just the shareholding, but holds voting rights through some specific arrangement, right to receive dividend, exercising of control, or significant influence. So the criteria is not just the shareholding, it is all these. If any such thing is there, then the beneficial ownership is to be checked. Provisions. Particulars of the member who is member, which is the registered owner. Like we discussed about the registered owner in the record. So who is the registered owner? And then the particular of the beneficial owner. And also attach the declaration, which is the Ben 1 is to be attached with the bottom. Moving forward, where we discussed that the obligation is there on the company as well to identify. So these processes are mentioned in the rules, the steps which company has to take. So company, if there is a reason to believe that there is a situation of beneficial ownership, then there is a notice prescribed in Ben 4, which is to be issued by the company. If there is a reason to believe that there is a significant beneficial owner in the company, having knowledge of the identity of SBO or other person likely to have such a knowledge. So even if there is via this external source as well, if there is any such reason to believe that there is a beneficial ownership, then also this notice in Ben 4 the company has to issue. To have been a SBO of the company at any time during the 3 years immediately preceding the date on which notice is issued. So not just current, but 3 years prior financial statements and other details also. If there is any reason to believe, then this notice the company has to issue, and who is not registered as a SBO with the company as required under the section. So this is obligation, and the person to whom such notice is issued has to revert within 30 days of the such a notice with the required information. And if no information is received or it is not satisfactory, then the company is to apply to tribunal within the 15 days of expiry of the period specified in the notice, order directing that shares in question be subject to restrictions. So if such a notice is not found satisfactory, or it is no information is received, company has to make application to the tribunal 15 days from the expiry of these 30 days which was there in the notice. So within 15 days, tribunal the application to tribunal is to be made, and the tribunal can issue orders relating to any like transfer of such an interest or like suspending all the rights attached to the state shares or any other restrictions. So this is what the powers have been given. Application to the tribunal, as we discussed, the reporting company shall apply to tribunal where any person fails to give information required in Ben 4 within the limit, within 30 days, if such information is not received, and where the information is not found satisfactory, the tribunal can be this application can be made. And section 90 subsection 7, the order which the tribunal can also issue in respect to such application is that there can be a restriction of transfer of the interest in shares, suspending the right to receive dividend or any other such distribution, suspending the voting right in relation to these shares, or any other restrictions in respect of the shares. So these orders which the tribunal can give. Tribunal, after giving opportunity of being heard, and the tribunal can make such an order within 60 days of the application. So this matter also has to be disposed of within 60 days. The company can also make application to relax the order, so that appeal also is possible within 1 year of order. And if no such application has been filed, or such this application for relaxation, so that if that is not filed, the shares shall be transferred without any restriction to IEPF in such manner as may be prescribed. No such application has been filed, such shares shall be transferred without any restrictions to IEPF. The penalty for the contravention is there. If the declaration is not made in Ben 1, then it is 50,000 on this 50,000 plus 1,000 rupees per day for a continuing offense, up to 2 lakh rupees on the person which is there. Then the company, if the company fails to file return Ben 2, maintain register in Ben 3, fails to identify the individual, which is Ben 4, if reason to believe and not done, or denies inspection as well, then 1 lakh rupees is on the company plus 500 per day up to 5 lakhs. And officer, which are the designated officer which we discussed, the 25,000 rupees plus 200 rupees per day up to 1 lakh rupees. If and in case any false or incorrect, misleading or surpasses any this material information which he is aware in the declaration, then he will be liable as a punishment for fraud under section 447. So that section will become applicable. So now we'll discuss some important terms which are a part of this beneficial ownership, which is which are in the definitions. So control, which is defined. Control is a big term, not just the shareholding as we talked that. It's not just the shareholding, but the control as well. What is the control? A right to appoint majority of the directors. This is a very critical aspect. Right to appoint the majority of director, control the management. Will all those side agreements or shareholder agreements, all those have to be seen. Wherever such a clause is there, the appropriate action needs to be taken. Right to appoint majority director, control the management. Policy decisions exercisable by a person acting individually or together, directly or indirectly, virtue of shareholding, management, rights, shareholder agreements, voting agreements, or any other manner. Special voting rights attached, special majority, all those have to be clearly checked and accordingly. So if this is hitting, then suitable action under this the company and also the individual has to check. Majority stake means that holding more than one half of equity capital in the body corporate. Body corporate is also like defined under the Companies Act, which is any entity incorporated outside India. So it's not just the company, but entity which is to be incorporated where it is a case of outside India. So having more than one half of voting rights in the body corporate, so equity capital, voting rights as well, and having rights to receive, participate in more than one half of distributable dividend or distribution of this profit by the body corporate, not just the shareholding, very critical. Partnership firm means and includes the limited liability as well, LLP. So SBO, now very critical, as we discussed indirect as well. So here it is defined in this. Significant beneficial owner in respect to reporting company means individual referred to this who alone or together through one or more persons or a trust possesses one or more of following rights in the reporting company. We are talking now of the reporting company. The individual who holds indirectly or together with direct holding. So not just direct shareholding, but indirect as well, as we discussed, indirect as well, not less than 10% of the shares. This is in the reporting company. So 10% direct as well as indirect, 10% or more shares. Again, not less than 10% of the voting rights in the shares. So shares, voting rights in the shares directly or indirectly, receive, participate not less than 10% of total distributable dividend or any other distribution. So direct, indirect, shares, voting rights, dividend or distributions, right to exercise or actually exercises significant influence, control in any manner other than through direct holdings. So this is there, and for this purpose, if an individual does not hold any right or entitlement indirectly under this, he shall not be considered to be a SBO. So individual, so no right or entitlement indirectly, then he shall not be considered to be SBO. Indirectly has to be checked. So for indirectly, the individual shall be considered to hold a right or entitlement directly if he satisfies any of the conditions. The shares in reporting company representing such right or entitlement in the name of the individual. So that individual is the registered owner. Individual holds or acquires beneficial interest in the reporting company under 89, section 89, and has made declaration in this regard to the reporting company. So individual and acting together. So acting together is individual or individuals through any person or a trust with a common intent, exercising right or entitlement, exercising control, significant influence over a reporting company, agreement or understanding as well. So all those agreements as we discussed, agreement, understanding, formal, informal also for the individuals acting together, and such individual or individuals acting together through person or trust as the case may be deemed to be acting together. So we have to see not just control, see influence, and also agreements, understanding, formal or informal. Understanding, so MOUs also has to be examined. Individuals shall be considered to hold a right or entitlement in the reporting company indirectly if he satisfies the following. So indirect holding we are talking about, where the member of reporting company is a body corporate. So body corporate, whether incorporated in India or outside India, other than LLP, any body corporate other than LLP, an individual holds the majority. So earlier we had a 10% of this. Now, for indirectly, we have to examine the majority criteria. So, holds a majority stake in that member or majority stake in the ultimate holding company of the member. So, indirectly, we have to also see the ultimate holding majority. So, any individual ultimately who is holding a majority, we have to see whether there is any this direct holding as well in the company. That has to be seen. So, this was other than LLP, and this is for a partnership. So through it is a partnership entity, whether through itself or through any partner. If any member, the individual is a partner in that partnership firm, holding majority stake in the body corporate, which is a partner. So indirectly, again, we are talking of indirect holding through a body corporate, which is a partner in that entity, and holds majority stake in the ultimate holding company of the body corporate, which is a partner of the partnership entity. So we have to go till the layers and because for partnership here we have mentioned, so this limited liability partnership, so partnership includes LLP as well. So that's right. Yes, sir. Ultimate holding. So ultimately, who is the individual to be seen? Two. Yeah, up to 2 layers is what is prescribed that we can have, but for this purpose, ultimate paisa kiska hai? Yes. Discretionary trust. We'll see. We'll see that. Yeah, we'll see in the subsequent rules. It will be there. So here, this here. So where member of the reporting company is a trust through a trustee, and the individual, again we are referring to the individual, is a trustee in case of a discretionary trust or a charitable trust, beneficiary in case of a specific trust, author or settler in case of a revocable trust. All three criteria are there. Member of this is a trust. Member is a trust, and the individual ultimately is a trustee, beneficiary, author respectively, and the member where the and also where the member of reporting company is the HUF through its karta, and the individual is the karta of the HUF. Then that has to be seen in case. So specific trust. So for a charitable trust, there is a trustee or this like any. Can never be beneficiary of that. No. No, for a charitable trust, we have to see the trustee. For a specific trust, for any like specific purpose, the beneficiary. So we have to, so that will also be depending. So we have to see from case to case wherever this is applicable. So where a member of the reporting company is a pooled investment vehicle, pooled or it is in like controlled by any such pool investment vehicle, or is a member of the FATF, like state of the FATF money laundering on money laundering, and the regulator of the securities market in such member state is a member of International Organization of Security Commissions, and individual in relation to that pool investment vehicle is partner, investment manager, CEO, or where the investment manager of such pooled vehicle is a body corporate or a partnership entity, and where the member of the reporting company is a pooled investment vehicle or entity is which is controlled by such a vehicle and which doesn't fulfill the above requirement, the routine test will apply. Where it doesn't fulfill these requirements and that these requirements, then the routine tests have to be seen, and whether there is this specific test is there, then these tests have to be seen. Instruments in the form of global like GDR or the instruments in the form of the GDR or like CCDs, the like convertible preference shares, convertible debentures also will be treated as shares. It is in line with the securities definition. So wherever convertibility is there, it will be treated as this. And significant influence means the power to participate directly or indirectly in the financial and operating policy decisions in the reporting company, but is not a control or joint control of those policies. So duty of the reporting company. So every reporting company, as we have discussed that the reporting company has to take necessary steps to find out if there is any individual who has a SBO. So one thing is individual directly comes and files a declaration, and the company also is duty bound to take steps to identify in relation to that reporting company, and if so, identify him and cause such individual to give this declaration in Ben 1. The reporting company in all cases where its member holds not less than 10% of shares, voting rights, or rights to receive dividend or this. So in all cases, 10% or more is the criteria for direct this. So if there is any such 10% or more, then the company can give notice to such members seeking information in accordance with this section 90 in form Ben 4. Where these rules are not applicable, these rules are not applicable for the authority constituted under section 125 or its holding reporting company, provided that the details of such holding reporting company shall be reported in form Ben 2, wherever holding company is there, or the central government, state government, local authority, or if a reporting company is a body corporate or entity controlled by the like government or any such this, whether it is a AIF or a REIT or InvIT, which is regulated by the SEBI. So such, if there is any such special regulated entity, then these will not be applicable. If there is any investment vehicle regulated by RBI, IRDA, pension fund or such, so these entities will be excluded from the reporting. So this was briefly about the beneficial ownership. We will move further with this. So here there is another amendment which has been notified under the compromise arrangement and amalgamation rules. So in cases that there is so this is about the fast track mergers which are there. So in that case, if there is no objection which is received within 30 days from the official liquidator or the ROCs, and the government is satisfied that scheme is in public interest or in the interest of creditors, then 15 days after the end of these 30 days, so within 45 days, the confirmation order is to be given in CA 12, like within 45 days, and in any case within 60 days of the scheme, if confirmation is not received, and if it is deemed that there is no like it will be deemed that there is no objection which is there, and the confirmation will be issued within 60 days. So it is to be disposed of within 60 days in all cases. That is one of the amendment. And where any objection is received in case from the OL or the ROC, and it is not sustainable, it is found to be not sustainable or in like public interest or creditor's interest, then 30 days after the expiry of the earlier 30 days, so again 60 days, then the confirmation is to be given in CA 12. Then if the government, based on the objections received or otherwise, it is held that the scheme is not in public interest or creditor's interest, then the application to be given before tribunal within 60 days of the scheme in CAA 13, the CAA 13 that the scheme is not this ideal for 232 section, so then it is to be considered not as a fast track merger, but the regular process will be applicable. So if the objections are found sustainable, then this is the step to be taken. And within 60 days, irrespective, no, if no objection is there, no application is made by the CG, then it is deemed that there is no objection and the confirmation order will be issued. This was another this amendment which was there by the this prospectus and allotment of securities amendment rule, where public companies wherein the now we are like touching upon the demat provisions as well briefly. So if there were any such warrants, share warrants which were issued under the erstwhile act, which was the 1956 act, within 3 months from commencement of these rules, so these rules were commenced on 27th October, so 3 months, so already they are over. They were to be informed to the registrar of for such a this share warrants. For so this was for a public company, whether listed or unlisted, was to be issued in the website as well as in the newspaper with the vernacular language in district. Circulation in district, so vernacular language and circulation in district, those like both has to be seen, and also in English language. And call for the respective holders of warrant to surrender those warrants and get the shares dematted. For public unlisted companies, the demat provisions have been made applicable, and for the share warrant, this was to be done. And if the bearer has not surrendered, then the company has to demat such shares and transfer the shares to IEPF. So this was the amendment. Then the dematerializing of securities for private companies were issued. So Rule 9B was inserted in this prospectus and allotment in these rules which were there. Rule 9B was for the private companies wherever applicable. So other than small companies, all private companies now have to mandatorily demat all the securities and also issue shares in demat form. Existing shares as well as new shares all have to be in demat form. So as on 31st March 2023, the cutoff date is this for determining whether the company is private company or small company. This date has to be considered, and within 18 months it has to be complied with. 18 months would be 30th of September 2024. And thereafter, any offer of issue, buyback, bonus, anything relating to shares, before making such an offer, these shares are to be dematerialized. Entire holding of promoters, directors, and KMPs also have to be in demat form, and these rules won't be applicable to the government company.
After that is from 30th September or 30?
Sorry, after
After that, then 30 September.
18 months, you are saying, or
No,
30th September 2024, by that time demat is to be done, and thereafter any such issue, buyback and all have to be in demat form.
before that, we can transfer.
If it is dematted now, then it has to be in demat form.
Without demand, if there.
Without demat, physically they can transfer, and then we have to have it into demat by 30th of September, and thereafter only in demat.
Certainly, this limited company having a paid-up capital of 5 to 10 lakhs. Are they covered?
We will cover
It's not.
unlisted, you are saying. Unlisted public, yes, they are mandatory. All unlisted public companies have to be unlisted public. Every shareholder, so once it is dematted, then every shareholder of private company for transfer or for private placement, bonus or rights issue, it has to be in demat form only, sir. Your question, post 30th of September, it has to be in demat only. Or once it is dematted, it is in demat only. Yes. So small company definition as well, it was amended in the previous year to expand the base of small companies. So Earlier definition was twofold, paid up capital and turnover, 2 crore and 20 crore. It was as per the new definition now, paid up capital has to be, as on the cutoff date is 31st of March 2023 for dematting. To so paid up and turnover it is 4 crore and turnover 40 crore. So if any one exceeds, this is 5 crore, this is within 40 crore, then also it is not a small company. If this is say 10 lakh and this is 50 crore, then also it is not a small company, it is a private company. Care to be taken.
This is a better capital is either one or both.
Both have to be done for small company. So if anything is exceeding this, anyone is exceeding, then small company, it's not a small company, it is a private company.
This definition was applicable for 2020.
Sorry?
It's applicable for FY.
Yes, with effect from 2023. Yes, like 31st March 23, you had to see. So 22, 23 onwards, it was made applicable. Yes, sir. And this is not applied to following companies. So small companies are not on following. So holding or a subsidiary company, these limits will not be there. So that also care has to be taken. So company under section 8 or a body corporate or this company which is governed by any special act. This is there. For a private company, so very briefly the rules we will discuss in the interest of time. Every company has to facilitate the demat of securities and like make application to the depositories, whether CDSL or NSDL, to have obtain a secure ISIN number for each type of security. Very important. Each type, each class is very important to be seen. For each type and classes, ISIN is to be obtained, and the shareholders have to be informed of the same. Shareholders have to have a demat account for the purpose of dematerializing and then submit their physical certificates to have them dematerialized. This is also another process which will have to be done. The RTA or a share transfer agent is to be appointed in terms of agreement has to be entered into. There is a also it has to be ensured that timely payment of the depository fees and RTA fees have to be made by the private companies. Depository fees also include, there is a one-time security deposit fee which is applicable based on the different depositories, and this is the also security deposit. There is a one-time joining fee and also the annual maintenance charge which is there depending on the slab of paid up capital. Those fees are applicable.
This is all securities including debentures.
No, not debenture, but convertible into shares, that has to be seen.
But after converting the share,
Yeah,
not like
equity and preference are considered. Equity, preference, and also if there are multiple classes, paid up capital, depending on that, or any rights, if there are there, then those are separate classes, so that will be included. Equity, preference. There is this past 6 which is to be filed every half year, the reconciliation of shares within 60 days from conclusion of every half year. That is for 31st of March, the half year ending 31st of March, it will be 30th of May, and for half year ending 30th September, it will be 29th of November. It is to be certified by chartered accountant or company secretary in practice. Particulars for each number of classes, there is a preference or equity. Your questions, a preference or equity. Data will be pre-filled. So that is one of the feature in V3 portal, that most of the data is pre-filled and there is an option to edit as well. It has led to convenience, but there are issues. So these classes will be pre-filled. The total number of shares, whether in demat or physical, held by promoter director, will be there. We can dispatch. We can. The total number of shares in physical or demat which is held by the promoter or director are to be disclosed. Share in demat in NSDL or CDSL with the particulars of DMAT, certifications is to be there by a CA or CS, and if there is any grievances, it is before the IEPF authority. So this was briefly about the dematting, and in the interest of time, we will. I also thought to cover some adjudication orders, not in detail, but just to give a gist of the things to be taken care of. So we'll discuss quickly the same. I have not included many details, name and all those details. I have just made a mention of penalties, the cause for which penalty was levied. These are fairly recent, like within a couple of months that way I have taken these orders. If anyone requires a full copy, they can get in touch. I can like share the full copy of the order as well for the reference. So first one is a private company. A private company has issued non-convertible debentures to 183 debenture holders. Now, what they did was they had or like open AIF platform which was there. They made they ran the platform was used to like advertise in a way. A private company is not allowed to advertise there. So this online platform was used. Applications were invited. There were pitching sessions as well held on social media platform. The promoters held the live sessions, Ask Me Anything, AMA sessions as well were held, which was all like the registrar received this information from SEBI and through other channels, and ultimately it was held as it was violation of section 42 subsection 7, which was this not to use any social media advertising platform marketing, and the penalty was imposed on company and its directors totaling to 1 crore 47 lakhs. Yeah, and also the penalty includes refund of the subscription money as well, that as per the provision. So this in this order, this penalty was imposed. It is especially in case of the startups which are blooming. This is care is to be taken. What, how to invite this, what to be used, what not to be done. This advisory has to be given. Second was that there was an inspection which was ongoing, and the company filed a reply. Director did not mention DIN number while signing. To the official reply, on every document where director is signing, DIN number is mandatory as per the act. This was not done, and for that the penalty was imposed, 50,000 on the company and 50,000 on the director. And it is the same company. The timeline, just see the timeline. Order was on 15th of April 2024. Minutes of meeting dated to November 2007, where Companies Act 2013 was not there. 2007, the minutes were not bound, they were not dated, and place of signature was not mentioned. This was found out in the same company where the number was there, and penalty was levied for non-compliance with secretarial standards, because secretarial standards under section 118 subsection 10 are to be followed, and also for non-compliance with 118, which is binding of minutes. So for this, both sections were levied. Next is the unlisted public companies not filed the annual returns from 14-15 till 22-23. Of course, the penalties were levied as per the act, because every year it is mandatory. But penalties were levied, but also this will not just involve penalty. Will this case also have to be seen whether AGM was held or not? Why it was not filed? Whether AGM was held or not? And also, what is the effect on disqualification? As per the 56 Act, it was a or condition, annual return not filed or financials, but now it is and. So both, so annual return not filed, in effect, directors have to be disqualified. So that also will have to be seen. Next was a private company had only one director on board for 41 days. We have to have minimum two. Only one director was there for 41 days, and also a non-resident director was there. Minimum one resident director is there for all the companies. There was one director which was non-resident. And also the gap between two successive board meetings was more than 120 days. Though all three provisions, the two successive board meeting within 120 days has to be convened, but it was exceeding. So penalties were levied under 149 section, which is for the directors, this minimum two directors for private company, and a resident director. 149(3) is the resident director, and also the gap between consecutive board meeting, which is 173. So these penalties were levied on companies and its officers. Next, a listed company again not file annual return for 2018-19. Show cause notice was issued, but the company made a response that the calendar year was the financial year. It was not the FY, which was April to March. It was, they were following calendar year. So they made a representation that it was a calendar year and it was ultimately filed on this date, which was within 30 days of the AGM. So it was found to be satisfactory and penalties were not levied. But so that representation, how it is made, whatever facts are to be put, they have to be properly put, otherwise it will be a trouble. We discussed beneficial ownership. So company did not file Ben 2 in another case. The reply to the show cause notice was also not found satisfactory. There is a very recent case as well on of a reputed company, which is also on Ben 2. So on examination of records on MCA portal, so the reply was filed, but all the official records on MCA portal, it was found that there were SBO instances of SBO. The company was claiming that there was no such instance, but it was found that there were instances. Contravention was established by the registrar and the penalties were levied. Next is the additional directors. This 2012 case in 2012, when the provision was not applicable to private companies, but 2012, because it was before the Companies Act, filed in 2019 because of any inadvertent. So the company claimed that it was an inadvertent missing out. So the contravention was there. Additional director was regularized in 2012, but it was filed with delay. Also for the financial statement, the registrar checked the financial statements in 2012, but the AGM notice did not contain the provision relating to regularizing of directors. It was only the approval of financial statements. So again, that was a gap which was there. So all those things have to be taken care of. This agenda item for regularization of director was not in the agenda item. So penalties were imposed on the company and directors. Next, the OCDs. OCDs, which is the optional convertible debentures, issued as a rights issue instead of a preferential allotment. A rights issue is only for equity and a preference share. This also very important to be taken into note. A debenture is not cannot be issued as a rights issue. It is only for equity and preference share. So the applicable preferential allotment under 62 read with 42 as well, which is a private placement. So these sections have to be carried out and not issued as a rights issue, the debentures. So it was held that rights issue is only for equity or preference share. OCD is under section 62 read with section 42. So all requirements of a private placement are to be mandatorily followed in case of debenture. The non-compliance was for 3 such instances of issue. So 3 times the debentures were issued under wrong sections. The plea was made to reduce the penalty owing to a small company and a startup company. So that plea was accepted and penalty was reduced to 25%. But this, because of wrong section, this was the penalty was imposed. Now, two very important and interesting cases of MSME. Currently, MSME provisions are not mandatorily imposed. They are not enforced. Basically, they are there in the act, but suitably, it is still in process. So one such this protecting the interest of MSME, one is MSME 1 form, which the corporates have to file every half yearly, and also with effect from I think this current assessment year or the previous assessment year, the Under section 43B of Income Tax Act also, the payments to MSME have been included. So that very recently it is still in process. But these cases are there wherein the complaint was filed by MSME supplier before the ROC that there were dues. The party had initiated proceedings before the magistrate court. So here the company has failed to file MSME one form, which is to be filed half yearly. The supplier has complained to ROC, and the reply that was given by the concerned company was that the proceedings were pending before the judicial magistrate court, and stated that payment would be made if the complaint was withdrawn. This was the reply. It was held in this case that the debt was acknowledged by the company. You had said that, yes, okay, it is there in the court, but you acknowledge the debt and there is no dispute. So penalty was levied because MSME 1 was not filed. There, so very critical. And similarly, another case for MSME 1, non-filing of MSME. But in this case, this current payment was due before the complaint was filed with MSME Facilitation Center, and therefore payment was overdue. Now, MSME Facilitation Center is for any disputes relating to MSMEs. So here this plea was given that there was any dispute, and therefore it was allowed as this the reason, and also it was mentioned in the form. The form was filed with delay, but this reason was mentioned in the form, and as it was sub judice, the matter was allowed and it was dropped, this complaint, because it was given that it is in dispute before the facilitation center. So these two contradictory cases were there. And I think with this, I conclude my session. Any queries?
But if you mention that, just like, if you regularize the right or don't right. Regularize means that able that or recent time upon that, it is required for regularize or.
The additional director or section 161 contains such provisions, and additional director's tenure of appointment is till the upcoming AGM. So that tenure ends, and that so now if directors are to be appointed, then they are to be at the AGM. So here that this agenda item has to be there, that this director is now appointed as a director instead of AGM of a additional director. And at the end, that change in designation has to be complied with. That instead of additional director is now a director.
The only requirement of that regularizing, right?
Regularizing, so the shareholders will appoint then that person as a director. Considering private company, that section 160 ka pura wo deposit and all those are not required. That the member will deposit some. So the section 160, that deposit, like filing deposit with the company, recommending the name, all that is not applicable to a private company. But then that in regularizing, if the resolution is passed that yes, this director who was the additional director is now appointed as a director, so that is passed, and then that DIR 12 is to be filed with the change in designation, that instead of additional director, that person is now a director. That is that. Yes, sir.
Hello, Raji is with us in the break also. So you can take the.
Yeah, sure.
Since we have two sessions after the.
Yes, sure.
So.
We can take it offline. Take the queries offline.
Thank you very much. Thank you.
Let me just take the vote of thanks, then we have the lucky draw, and then we proceed for the break. On behalf of the JB Nagar Study Circle, I wish to extend a hearty vote of thanks to CS Raj Kapadia. We have made elaborate presentations leading in the company not related to private limited companies. He has explained the relevant circulars, changes with relevant examples, practical case laws, and also topics like beneficial ownership and the changes in forms and the way of the forms are being processed now. We thank you for taking the queries and also the queries that you'll be taking later in the day. I would also like to extend my appreciation for the coordinators who have helped us in the smooth conduct of the meeting today. Last but not the least, a big thank you to all the participants for making it a wonderful session. Now, before we take the lucky draw, just a few announcements. We will take a quick break because we have two speakers after the break. So I request you all to please assemble back within 15 to 20 minutes for the second session. And also the arrangement of Jain food has been done near the tea stall. So anybody who is interested in Jain food can stay there and the others can proceed to the higher level. Now, I would request Raji to take out two lucky draw from the board. Thank you.